So, hello everyone. Welcome to this live stream from LiveLaw Academy. Today we are here with Advocate Yuvraj P Navankar, and we're here to discuss about the expansion of primary evidence and practical implications in the trials under the Bharatiya Sakshya Adhiniyam 2023. We're also launching a new course, Deciphering the New Criminal Laws and Exploring Changes and Beyond. Stick around till the end so I can give the details about that. So we can go ahead with the discussion for now.
Hi. So basically, as she said, we are going to talk of the primary evidence and its considerably expanded scope in the new Bharatiya Sakshya Adhiniyam. In fact, I must indicate the Bharatiya Sakshya Adhiniyam is going to throw many interesting challenges at the legal practitioners. And one of the major ones being, which I anticipate, is the expansion of the scope of a primary evidence. Because, primary evidence has always been, from 1872, from the day the Evidence Act was enacted, has always remained a static concept. There has never been an amendment to the concept of a primary evidence. It's exactly in the same form as it was in the year 1872. And therefore, it's going to be a topic of curiosity and topic of interest as to how the expansion will be tackled by the judicial fraternity. Just to elaborate on this, the primary evidence has always been understood to mean a document which itself is produced for the inspection of the court. For example, if I am relying on a cell deed, and when I say primary evidence, the first thing that comes to my mind is the original, duly affirmed, executed, registered cell deed. When I submit that in the court of law for the inspection of the court, I call it a primary evidence. And then law tells me that that's enough. I don't need anything further because primary evidence is the best evidence. When I go into the territory of a secondary evidence, suppose if I don't have the original evidence, suppose if I don't have the original cell deed, I will try to produce in the court the Xerox copy of the original cell deed, which I was told is a secondary evidence. The copies made by the mechanical process from the original was what was called as a secondary evidence by the old section 65 of the Indian Evidence Act. So I have something now very fixed in my mind that the original is a primary, the copy is the secondary evidence, is what I was always taught and what was always the position. Now the Evidence Act in its new avatar, if I may call it that, in the Bharatiya Sakshya Adhiniyam, completely topples or completely turns this concept on its head. And for that, if you look at the new section 57, which now takes care of the primary evidence concept, Section 57 per se is not changed, I must indicate. Section 57 still defines it in the same manner as it was originally defined in Section 62, that the primary evidence means the document itself produced for the inspection of the court. What is very interesting are the explanations which are added to Section 57. And I will request the readers, maybe if they have an access now or maybe after the session, to please visit those explanations, because the explanations have been considerably expanded. The explanations which were few earlier, now there are almost 7 explanations, and 4 of them are the added explanations. Just as an illustration, and obviously we'll be talking at length in the session that we are going to have on the repercussions of these illustrations. But just to give you a quick teaser on it, explanation 4, if you look at the new Bharatiya Sakshya Adhiniyam of section 57, it says when electronic record is created and stored simultaneously and sequentially in multiple files, each of this is going to be the primary evidence. See how there is a complete change of a regime. Earlier, we were told that if this is a document, and if I make a Xerox of this document, the copies made from the mechanical process will be secondary evidence. Now, what the explanation is telling me is this, that when the document is created simultaneously or sequentially, each of the copy is a primary evidence. So now there is a complete shift of a regime for the electronic evidence. What earlier could have passed the muster as a secondary evidence is now being labeled as a primary evidence. And therefore, suppose if I take prints of a file on multiple pages at the same time from maybe different printers or from the same printer at multiple times sequentially, because it also uses the word sequential, then I may, within my right, to argue that each of these copies you please treat it as a primary evidence, because they're all made in sequence, they're all sequentially made into multiple files, and therefore don't call it a secondary evidence. But now there will be a direct conflict with the secondary evidence concept in the Bharatiya Sakshya Adhiniyam because it still retains the original terminology of a secondary evidence, copies made from the original by the mechanical process. So whether the multiple printouts, will that be a secondary evidence or will that be a primary evidence going by this explanation 4 is going to be a point of a contest in the courts. Come to explanation 5, the same anomaly you will see there. When an electronic record is produced from a proper custody, then the electronic record is a primary evidence. Now see the problem. Suppose if I am an ethical hacker and I'm appointed by the police to hack into someone's account and procure the documents. Now you are all aware of the concept of ethical hacking. It's a legitimate hacking. It's still hacking, but it's a legitimate one. I get some certain documents without the consent of the in charge of the computer, who was supposed to be the person who is supposed to give me the consent to procure. You obviously doesn't give me a consent. I hacks into his system. Police wants me to give these documents into the evidence because that's what it was all meant for. It was supposed to be there for the evidence. Am I the proper custodian of those documents, technically speaking? Because I am the hacker. At the end of the day, I am the hacker. I have not entered into the system with the permission of the owner that the law contemplates. That's what IT Act of Section 43, if you see, if you access someone's system without his permission, then you are the hacker and you are liable for civil penalty. You are also liable for the criminal penalty under Section 66 and the subsections. So I am technically not the proper custodian of the documents. But law is telling me that if the document is coming from a proper custody, then document is a primary evidence. The document coming from an improper custody is going to be a secondary evidence. Now see the problem. You would all understand and appreciate this, that the primary evidence per se as a concept had never to do anything with the source of the document. Suppose if it's the original sale deed I am producing, the classic case of a primary evidence, the original executed sale deed. If X produces it, it is still the primary evidence. If Y produces it, it's still the primary evidence. If Z produces it, it's still the primary evidence, because the primary evidence as a concept is a document-centric concept. It's never the person-centric concept. So it may come through anyone. The custodian will not decide the nature of the document. It is the document itself that will decide the nature of a document, was the scheme of the old evidence, and which is still retained by the new act, because the concept of primary and secondary are not done away with. They still retain their places in the new BSA. But now the act says the proper custody, if it comes from a proper custody, it will be a primary evidence. If it comes from some other person's custody, it will be a secondary evidence. See, the problem for the practitioners will be this: whether the ethical hacker's custody is a proper custody or not, it will take an entire trial to decide. See, primary evidence, if I submit that in the court of law, I don't need any proof to corroborate that. That's the end of the story. It's the best evidence. It's proved. It's exhibited. It's marked into evidence. That's the end of the story. But a secondary evidence will need a more corroboration for the document to be read into evidence. As you will all know by the scheme of the evidence act, secondary evidence is a weaker evidence. It needs more corroboration. Now, if suppose I put a document into the evidence as a primary evidence, and if I'm, if I am now at leisure saying that, no, I don't need to do anything further because the primary evidence has passed the muster, I don't need to do anything. At the end of the trial, to my horror, I realized, no, it was not a proper custody. The ethical hacking is still a hacking, therefore it cannot be called as a proper custody. What happens to the document which is already marked into evidence? Because that has passed the muster, it has been exhibited. And therefore it will take an entire trial to arrive at the finding whether the custody is a proper or not. And therefore it was not right on the part of the legislature to keep this issue dependent or contingent on the custody. This had never happened before in the scheme of the Evidence Act. Okay, and the last, and in fact, as I said, that we will have the answers to all these questions and anomalies, and when we have the session in length, at length. But let me also leave you with one more question, or maybe as a food for thought, is suppose if I call these evidences a primary evidence, okay, then is it that I don't need to do anything further? Or the law still requires me to do the certification as we used to do under 65B earlier? Because you all are aware that the moment I give the primary evidence, I don't need to do anything further. It will speak for itself. But is it the same case about all these documents that we just spoke of? If it's an email coming from my custody, it's from my email account. Suppose it's from my email account. I am the custodian of my email account. So it's a document, original one, from a proper custody. The law is now calling it a primary evidence. Is the legislature telling me that, Mr., you don't need to do anything further, you have given the best proof, so go home? No, that's not the case. The formalities are still there. So it will be now of much interest to reconcile these two conflicting positions. On one hand, you are elevating it to a status of a primary evidence. On the other hand, you are still retaining the formalities which you had in place for the secondary evidence. So I think these all things we will discuss in the sessions that we are looking at. And in fact, apart from this, I must indicate the Evidence Act has undergone, I would say, very subtle changes. I have heard many people saying it's a old wine in the new bottle, but I strongly differ with that, because the changes are so subtle that it will take us a time to understand it's a new wine in the new bottle, because I think it will take us few trials, few judgments, and a little jurisprudence to understand and come to the terms with the reality that the things have changed, really changed. And I think as a practitioner, it's our duty to understand what are going to be the repercussions of these changes, because we cannot do trial and error with these new changes. I think we have to be ready to cope up with the challenges it's going to throw at us. And yes, and we will discuss more challenges and we'll try to find the solutions in the sessions that we are going to have soon. So yeah, thank you. I think that was my bit on this.
Thank you, sir. Thank you, sir. So as you said, since there are so many nuances and so many slight changes, it's especially important that everybody comes to know of this. When we come across such judgments, we should be aware of what already is there. And thank you for that, sir. I'd like to now explain what the course is and explain the details of the course. So this is a short course of 16 hours. It will span for up to 8 days. It's an 8-day course, and we have Saturday off. So it will start on the 22nd and end on the 30th. So the timings for every day are 6 p.m. to 8 p.m. with Saturday being a holiday. The faculty, let me introduce the faculty to you. So we have Professor Dr. Vageshwari Deshwal, who is a professor of law, Faculty of Law, University of Delhi. Professor Dr. Mrinal Satish, Professor of Law, National Law School of India, University, Bangalore. Advocate Nandita Batra, a practicing advocate of Supreme Court of India and formerly an assistant professor of law, NLSIU and NLUO. And finally, sir, Advocate Yuvraj P Navankar. Thank you for your discussion, sir. Sir is a practicing advocate in the Bombay High Court and the Supreme Court of India. He's also a gold medalist in LLB, ILS Law College, and in LLM, Mumbai University. He has been practicing for the last 14 years and has several reported judgments to his credit. He's also a senior advocate, Panel A, for the Union of India and state undertakings. He's also the author of Electronic Evidence in the Courtroom, a Lawyer's Manual by LexisNexis. And he also has a conferred fellowship of the Chartered Institute of Arbitrators and much more to his name. Let's look at a few of the queries that we get. So all the participants will be receiving a certificate by the end of the course, and we'll also be providing time-bound recordings. So they will be available for a week from the end of the course. So this is not just for people who may have missed the classes because of timing difficulties. It's also, since we're looking at so many nuances, it's also if somebody has doubts and wants to rewatch videos, you'll receive the recordings. And I'd like to mention that this course is not only for lawyers and law students. Since there are so many changes happening in criminal jurisprudence, we ought to know all of the interested citizens of the country ought to know all of this. And the registrations will be open till the end of the day of the 21st of July. So we're looking forward to having all of you. So I think with that, we can end this thing, unless you have something to add.
No, that's it. In fact, even I look ahead to the sessions, because this is the first time we will be discussing something that has come to us for the first time. And it will be a brainstorming session in a real sense, because, we are looking at something that we have never tested before. So yeah, it is going to be probably a very interesting session. Yeah, looking ahead to it.
So looking forward to having all of you. Please make sure to register. And all of the links will be in the description box, the link to register. And you can look at more courses which will be available on the LiveLaw website. And you can find the link for that in the description as well.
Thank you. Thanks.
Thank you. Thank you, sir.
Thank you.
Yes, I've ended the stream. What will I mean?